Hello, everyone, and welcome to our continuing series of Employee and Labor Relations live stream training. I am Marcus Fuller, Labor Relations Specialist with Accountability and Workforce Relations, which is a component of Employee Services at the U.S. Office of Personnel Management. Accountability and Workforce Relations provides guidance and policy in the areas of federal employee and labor relations. Today's live stream will provide a comprehensive review of contractual provisions and FLRA case law pertaining to permissive subjects of bargaining. Note that any opinions expressed are those of the presenter and not necessarily the official position of any federal agency. We are delighted to have an expert with more than 40 years of labor and employee relations experience in both the private and public sectors here for this session. John Clea is a labor relations specialist with accountability and workforce relations at OPM. His responsibilities include legislative and policy analysis, FLRA case analysis, training instruction, and training development, such as intermediate negotiability and other advanced labor relations topics. We believe you will find permissive subjects of bargaining to be a very informative topic. If you have questions for our speaker, you can send them to awr@opm.gov. If time permits, we will respond to questions towards the end of the broadcast. We now turn the presentation over to John Clea.
Thank you, Marcus. Good afternoon, everyone, and welcome on behalf of Accountability and Workforce Relations Employee Services here at OPM to the live stream Reclaiming Management Rights, Terminating Permissive Provisions in Labor Agreements. My name is John Clea, and it's my honor to have you as guests for this training. It occurred to me that in doing this training, I should provide you some background information and not just throw you cold turkey into the subject matter of permissive subjects of bargaining. And so I'm going to give you some background information, and it's not in your outline, and hopefully you'll make notes and take it into account in applying your training. Part of the mission of our agencies is effective and efficient government on behalf of the American taxpayer. In performing that duty, agencies must analyze the existing provisions contained in their collective bargaining agreements, supplemental agreements, memorandums of understanding, and the like, in order to determine whether or not the provisions are permissive and to decide whether or not those provisions continue to serve the federal government. In order to do that, it's necessary to understand exactly how a permissive provision is defined and understood under Federal Service Labor Management Relations Statute and its relationship to other subject matter that may or may not be negotiable and how they are defined. Subjects of bargaining have been classified into three groups: mandatory subjects, prohibited subjects, and permissive subjects. Let me put that into context by way of examples from the Federal Service Labor Management Relations Statute, which from now on I'm just simply going to call the statute, examples which you should be familiar with. As to mandatory subjects of bargaining, this is subject matter that the statute or decisions of the FLRA or even other statutes require that you must negotiate. Some examples are procedures and arrangements bargaining under 5 United States Code 7106B2 and B3, which you are required to bargain about upon request from the union. Or as another example of a mandatory subject, the FLRA has determined that ground rules are mandatory subjects of bargaining. Or, as to other statutes which make subject matter mandatory, we have alternative work schedules under 5 United States Code 6101. As to prohibited subjects of bargaining, that subject matter is contained in 5 United States Code 7106A, and that is what we refer to as management rights. And these are subjects on which agencies and unions may not bargain because the law prohibits the parties from doing so. Now, here's a practical tip that I use myself, and I've passed along to other people who have attended training about understanding management rights and why and what is not negotiable about management rights. So please consider the following. Deliberations within an agency on management rights, the decision to act on a management right, or the decision not to act on a management right, these are subjects that are non-negotiable and for management alone to determine. I'm going to go back through that again. Deliberations within an agency on management rights, the decision to act on a management right, and the decision not to act on a management right are non-negotiable and for management alone to determine. So the practical matter is that when you get a proposal across the table from the labor organization, you need to look at it and look at it very carefully. And is there something in there where they're interjecting themselves into decisions on management rights? And if they are, you should state that's a non-negotiable subject. All right. The Federal Labor Relations Authority, that's the FLRA, in a case involving, of all agencies, OPM, 51 FLRA 491, they clarified some of their negotiability terminology and noted that they would no longer use 3 older terms: permissive, prohibited, and mandatory. Instead, they indicated that they would use the terms within the duty to bargain, or negotiable, with respect to what were formerly called mandatory subjects, and with respect to prohibited and permissive subjects, the FLRA indicated they would use the terms outside the duty to bargain or non-negotiable. And now that I've thoroughly confused you, just keep in mind that the terms mandatory, prohibited, and permissive are still in common usage among practitioners and the FLRA, and those terms have appeared in decades of FLRA case law. So we've given you a citation, and there's some new terminology or terminology that you could use to replace the terms permissive and prohibited and mandatory, but those terms continue to be used by practitioners and the FLRA. As to permissive subjects of bargaining, that is the subject matter of the live stream and the questions and answers in the outline, which we will shortly address. In taking the subject matter of this live stream and in applying it to your real-life duties and responsibilities, it's absolutely vital that you review all agency collective bargaining agreements. Yes, you have to read them thoroughly, completely, and with an eye to what we're going to talk about, permissive subjects within those contracts. And you have to review your supplemental agreements for permissive provisions, or you may have memorandums of understanding that have permissive provisions in them, and sometimes you may call an agreement something else that might have a permissive provision in it. And your job is to identify the provisions that are permissive and which can and should be removed from your labor contracts by using the information that's going to be provided to you. If you don't take this step, then you're simply not doing the job that you were hired to do as a specialist for your agency. And now let's proceed to the substance of the questions and answers. This is just a note that was included in your outline, but the last part of this is important. When referring to these frequently asked questions and answers, I'm cautioning you, check the most current FLRA case law, as agencies have to decide for themselves how to address the continuing applicability of the cases that we're going to cover in light of not only 70 FLRA 398, but any future authority decisions. All right, on to question number 1. How do permissive subjects impact bargaining obligations? And our first answer that we've given you in the outline says that no party is required to negotiate on permissive subjects. And we've given you one case that stands for that proposition, and there are others, and you'll find them frequently quoted within many of the cases that are in this outline. So no party is required to negotiate on a permissive subject. Question number 2, can you withdraw from permissive bargaining? And the answer is yes, and that includes any time before you have signed off on the contract and included a permissive provision. So you might get up to the last set of subject matter in your bargaining, and your agency decides, we've been bargaining about permissive subjects, and so you are entitled to say to the labor organization, no, we are withdrawing now from bargaining about permissive subjects. So you may withdraw from bargaining over permissive subjects before you have reached an agreement. And we've given you a case citation for that proposition. Now, question number 3 involves, are agreements on permissive subjects binding on the party? The answer is yes. And what's the practical effect on you as an agency negotiator or labor relations specialist? Once you sign off on that provision, once you agree to it, once the whole contract is before head of agency for review, here is the law. Once you've reached an agreement on a permissive subject at the bargaining table, it's binding on the parties, and agency heads may not disapprove permissive topics upon review under 5 United States Code 7114C unless that provision happens to be contrary to some other law. So, you agree to a permissive provision, you agree to the whole contract, off it goes to head of agency. You bought it, head of agency can't save you from having agreed to that permissive provision. Now, our next question is, can either party insist the impasse on a permissive subject bargaining? The answer is a plain and simple no. Parties may not insist the impasse on permissive subjects of bargaining. And so what is the consequence if you do go down that road? You insist at the bargaining table that the union agree to a permissive subject. The consequence could be that you have an unfair labor practice filed against the agency, and it is an unfair labor practice for either party to insist the impasse on a permissive subject of bargaining. And we've given you that case citation Social Security Administration 64, FLRA 17. I wanted to pause and say something about your need, and it's absolutely vital, it's critical that you read these cases. You're not going to understand the nuances unless you read the cases. But even more importantly, buried in these cases, you can find a lot of good things to assist you at the bargaining table and to assist your understanding of the subject matter. For example, in this case, the insistence to impasse was on matters covered by the master agreement. So, you received this demand to bargain midterm from the labor organization because you've made a change. Are you just going to agree to bargain about it? Well, not if you read this case and understand what it means in terms of your a weapon for you to apply. To say to the labor union, oh, wait a minute, you know, the things that you've proposed to bargain about, the subject matters are already covered by the master contract. And if they are, this particular case is communicating to you that the covered by doctrine is a defense to negotiating about subjects already covered by an agreement. So insistence to impasse on matters covered by an agreement can land a labor organization in the soup, and you could file a ULP against them. Now, this particular case also, in reviewing it, I thought it was kind of nifty because as I'm reading it, I find within it some information about regressive bargaining. I was familiar with regressive bargaining and the concepts of it because I came from the private sector and the public sector outside of the federal government where we used it. We used that terminology. But here in this case, you actually have the FLRA talking about regressive bargaining in the federal sector. So if you didn't read this case, it'd go right by you. And yet it's a weapon that you can use when you're at the bargaining table to say to the labor organization, say, we thought we had this agreed to, and now you've gone back to square one. That's what happened in this particular case. The union kept going back to square one. They kept insisting that the memorandum of understanding that they presented at the first session be agreed to by the agency. And they kept going back to it, and they kept going back to it. And the judge in this particular case mentioned that as being at least an indication of regressive bargaining. And the FLRA, it's what attorneys call dicta. It wasn't something that was central to the decision about the fact that insistence to impasse on matters covered by an agreement can get you in a ULP posture, but they stated, and something at the very tail end in dicta, it's note number 9, that, however, with respect to the judge's finding that the respondent, that was the union in this case, engaged in regressive bargaining, we note that under both authority precedent and that of the National Labor Relations Board, withdrawing a tentative agreement does not by itself establish bad faith. But what they're really saying is it's an indication of it. So to put it another way, a party's withdrawal, and this is right there in the footnote 9, A party's withdrawal of a tentative agreement or a previous proposal without good cause is evidence of bad faith bargaining, but the withdrawal does not establish per se an absence of good faith. So the point here is you have to read the cases. I understand that we all have tools available to us to assist us in bargaining, and we have research tools available to us. But sole reliance on these research tools is not going to get you where you should be as an agency labor relations specialist. You need to be able to take a case, parse it, tear it apart, figure out what it means, and go on to apply it to future situations. All right. Let's move on to question number 5. What matters are considered to be permissive subjects of bargaining? Well, the most frequently cited one that you're probably already familiar with is those subjects that are referred to in 5 United States Code 7106B1. And those are permissive subjects of bargaining, or you will hear you'll frequently see the FLRA or hear them talking about those subjects are negotiable at the election of the agency. They may not say that those are permissive. Instead, they'll probably say that those are negotiable at the election of the agency. So in addition to those matters which are outside the required scope of bargaining under the Federal Service Labor Management Relations Statute, the statute, such as waivers of statutory collective bargaining rights or provisions in collective bargaining agreements dealing with the statutory relationship between the parties, are also considered to be permissive subjects of bargaining. So, and we'll see it in our training. So what you really have is 3 separate branches of permissive subjects. One is B1 matters. One is matters dealing with a waiver of the statutory rights of the parties with respect to bargaining, and we'll have some examples on both sides of the fence. And then the other strand is related to the statutory relationship between the parties, and we'll have examples of those types of provisions as we move along in the training. So let's do a little bit of a look at these B1 subjects. I'm not going to read the statute back to you. You can take a look at it on your own. But the statute does first mention numbers, types, and grades of employees or positions assigned to an organizational subdivision, work project, or tour of duty. And we have a case involving numbers, types, and grades as a permissive subject of bargaining. And that case, 51 FLRA 386, once again, when you read it, you realize it's got a lot of good stuff in it. If you don't read it, it just won't come home to you as well as it should. So this particular case is good on what the FLRA has given meaning to the words tours of duty. So if you looked at this case and read it before the training, proposal number 1 involved adding employees to an organizational subdivision of the agency. And that involved the tours of duty of the folks that the proposal involved. So if you read it, you'll get a good understanding of what's meant by tours of duty. If you don't, well, quite frankly, the book learning won't help you out because You could look up tours of duty, but you'll never see it as actually applied in an FLRA case. And this one is also very, very good about the relationship between 7106A of the statute and 7106B of the statute. So this is one I highly recommend that you read outside of the idea and the concept of permissive subjects of bargaining, B1 subjects, because there's a lot of good stuff in it. All right, let's move on to the second case citation and numbers, types, and grades. And that includes the idea of the establishment of staffing patterns or the allocation of staff, as I already mentioned, to an organizational subdivision that was involved in the first case. Or, this is kind of nifty, vacant positions. So you might get a proposal from the labor union that says, fill these vacant positions. And if you didn't read the case and didn't understand what it stands for, it might not immediately hit you that, say, the idea of numbers, types, and grades includes the concept of filling vacant positions. So if you knew that, and across the table comes a proposal involving a B1 subject, and the idea, the proposal involves filling vacant positions in an organizational subdivision, you should be able then to tell the labor union and frankly, it's a B1 subject matter, it's permissive, and we now choose not to negotiate about it. All right. These cases cited here also involve the number of shifts assigned to employees. So on the surface, numbers, types, and grades looks easy to understand. But beneath the surface and looking at the cases, you begin to realize, oh, there's a lot of good stuff here. So one of these cases involved the number of shifts on an alternative work schedule. And that was related to tours of duty, and therefore it was what? A permissive subject of bargaining. And the agency was justified to say to the labor union, permissive subject of bargaining, we've already decided that we're going from 5 shifts to 3 shifts, and we're simply not going to bargain about that permissive subject. So, but if you hadn't read and understood all of the nuances of the things that are within the concept of numbers, types, and grades, and within the words used in the statute, you wouldn't be able to say that to the labor union across the table. Now, let's move on to technology, method, and means. This is a very interesting case that's cited, 40 FLRA 831, that actually involved the use of beepers. That's old school stuff, technology, but it's nevertheless, the use of beepers off-duty is a method and means of performing work. So what are we doing here? We're digging into the words method and means, and the FLRA in these cases is giving them meaning. But if you didn't know that something like the use of beepers involved the method and means of performing work, you couldn't say across the table that's a B1 subject and we're not interested in bargaining about that. So you simply have got to read the cases and understand what the words mean. Now, I will say this. The FLRA does not easily distinguish between the words methods and means, and they tend, as they did in some cases, they'll just say, this proposal involves the method and means of performing work, without distinguishing whether it's method or means. And what I'm saying to you is, don't get all hung up on, is it a method or is it a means? Because what I'm saying to you is, the FLRA doesn't get all hung up about that. They kind of lump the two terms together when they're talking about method and means of performing work. And in this final case, for those of you who may have technicians, National Guard folks, the wearing of a military uniform at work is a method and means of performing work. You would never know it unless you read 64 FLRA 1194. So the point of all of these cases is there's a lot of wine that the FLRA has poured into these words. And you have to read and understand what they mean in order to be able to effectively bargain and negotiate for your agency. Now, let's move on to question number 7. What are some examples of permissive of subjects of bargaining other than those contained in 7106B1? And we'll go through these slowly but carefully. Contractual provisions regarding the relationship between the parties are another example of a permissive subject of bargaining. In this FAA case, which we cite, the FLRA determined that a negotiated provision in the contract which designated the sector representatives or representatives of the labor union, but a provision in the contract which designated sector representatives for the union was a permissive subject of bargaining. And therefore, on expiration of the agreement, and with specific notice to the agency from the newly certified labor union, the agency could no longer rely on this permissive provision they had negotiated with the predecessor labor union. So this stuff about, the point is, the stuff about terminating permissive provisions, you may have that applied by a labor union to you. So you have to understand that these concepts go in both directions. The provision that was in 15 FLRA 407, you have it in front of you, and it gives you some idea, and the reason I put it there is so that it gives you an idea of what a permissive provision actually looks like. Pulled it right out of the case, verbatim, and it shows you that here the union agreed to a provision about sector representatives, etc. Now, what they could have done and not negotiate this provision is say to the agency, look, that's our statutory right as a labor union to decide who will represent us where and when. And frankly, it's a permissive subject, and we're not interested in putting that provision in the bargaining agreement. Again, the arguments are flowing in the opposite direction, and they're saying to you, we're not interested in negotiating anything about that, who our reps will be, because it's a permissive subject. Now, whether that's wise, that's up to the labor organization. I just want you to know that the concepts we're learning flow and can be used by labor unions. Now, this is on page 3 of your outline that I've turned to. This same principle about designation of representatives applies to agency reps. So in the particular proposal that was in this case, 21 FLRA 580, the union proposed that the commissioner, yeah, we're talking about the commissioner of the agency, and the president of the labor union will personally attend all mediation sessions held under the auspices of the FMCS. That was a proposal that involved a permissive subject, because applying the same concept as unions designating who's going to represent them and where, that same thing applies to agencies. So in this case, the agency said, whoa, wait a minute, stop. We're not interested in having you tell us that our commissioner has to show up at an FMCS proceeding. It's a permissive subject, and we're not interested in bargaining about it. That's all that has to be said by the agency rep. So that one is the designation of agency reps. And you have the exact proposal that I pulled out of the case. Now, as to the relationship between the parties, which is what we're talking about as a permissive subject, the relationship being who's the union rep, who's the agency rep, that's the relationship between the parties. Another example is the delegation of bargaining authority. And this one is a real good one to be aware of, because a lot of you do bargaining at the local level. And that local level agreement may contain permissive provisions. So in this particular case, the FLRA determined that a clause in the contract relied upon by the FAA to continue its prior practice of notice to local union official about changes in conditions of employment. That's the key. A change, that's, what are we talking about? Impact and implementation bargaining. Was a permissive subject of bargaining, and that any such delegation which had been relied upon by the agency was revoked by this newly certified successor labor union in letters to the agency, notifying the agency that its president was to be the new point of contact for notice of changes in conditions of employment and impact and implementation bargaining. So once again, we're learning about permissive subjects and how they apply, and we're learning that one tree of the permissive subjects involves the relationship between the parties, and that the concepts apply in both directions. They can be applied by the unions to provisions that are in agency contracts, and they may send you a letter that says the contract's expired, and all that good stuff in there that used to apply to the predecessor labor union about who you should contact and notify about a change in conditions of employment and who's authorized at the local level to bargain no longer applies. So you have to pay attention to the stuff that the union sends you about permissive subjects. So in addition to us focusing on identifying permissive provisions, we also have to identify the stuff that is coming from the labor union that may involve permissive provisions and to which you want to say, if it's something they want you to do, you may want to say to them, that's a permissive subject and we're not interested in bargaining about it. All right. There are some very rare examples towards the end of this section about the relationship between the parties as being a part of permissive subjects of bargaining. And that involved mixed units of supervisory and non-supervisory personnel as being a permissive subject of bargaining. You're very unlikely to run across that situation, but if for some reason you still have a mixed unit out there, just realize that there's cases that state that the continuation of mixed units of supervisory and non-supervisory personnel is a permissive subject of bargaining. Now, finally, agreements to bargain below the level of the agency at which bargaining between the agency and the union is required, known as the level of recognition, are permissive subjects of bargaining. Again, relating back to many of you do bargaining at the local level, but most of that is based on provisions in your master labor agreement. Now, in this particular case that's cited, 62 FLRA 174, we have a fine example of an agency waiving a right of management and agreeing to something that otherwise shouldn't be in a contract. And in this case, if you read it carefully, what went on was the agency waived a prong of the covered by doctrine. That was permissive. Should they have done that? John's opinion is no, but they did it. So when you're looking at your contracts, you're looking for stuff like this that's got to go. Now, this case is also interesting because the union made a mistake here. There's a concept called severance of proposals in a negotiability case. And in this particular case, the union said to the FLRA, look, consider proposals A and B and C and D and E and F together. Together, that's what they said. Now, the FLRA looked at that request from the union and said, oh, that's not severance as we define it. It's some other animal. But you know what? We're going to apply the same law of severance to what they asked us to do, meaning that if they found one of the proposals non-negotiable, both of them went down. And that's what happened. They looked at these proposals they were asked to consider together, which were not severed, and found that, oh, the first one's non-negotiable, therefore the second one that they asked us to consider along with it goes down with it. Now, that's an important point to keep in mind. It's a very nuanced point, but it's an interesting one to be aware of. And this is an excellent case on local negotiations being permissive. This is just a super case to understand that bargaining at the local level is a permissive subject. The certification is normally held by the National Labor Organization, and the negotiations on the master agreement set the tone. And you just need to read cases like this to understand that bargaining below the level of recognition is a permissive subject of bargaining. And finally, this last case is a really wild one. And I tried and I tried and I tried and I tried. How do I sum this up for you guys who are watching and who are our guests in the training? You know something? I was stumped. So I'm going to just ask you, read this thing. this case because it explains how, having agreed to all of this stuff at the local level, local MOU, local this, local that, how an agency got itself out of those permissive provisions. All right, moving on. Are waivers of statutory rights, this is question number 8, permissive subjects of bargaining. We've already had an example of that. The answer is yes. I mentioned that some agency waived a prong of the covered by doctrine. And in that particular case involved here, the union did that. The union waived a right given to it by statute. And that proposal that showed that it had waived it was if an agreement's not reached by the parties after 45 calendar days from the date union requested negotiation, the employer has the right to implement the proposed changes and conditions of employment, even though the matter's been referred to a third party for resolution. And normally, under those circumstances, a status quo might apply to the agency. But this union agreed to something very favorable to us on management's side. And you just need to be aware that some of the provisions that you'll spot that are permissive and which you'll have to decide about and whether or not they're favorable or unfavorable, whether or not you want to send a notice to get rid of them, you have to be aware that there are instances where these permissive provisions are favorable to agencies, such as in this example. All right. Another good example of permissive provisions, permissive subjects of bargaining involves the conditions of employment of managers and supervisors. Now, those are permissive subjects of bargaining. There's a whole laundry list of FLRA cases where they've said that. Now, I put in at the end of this outline a case that comes from the D.C. Circuit. And why did I do that? Well, the D.C. Circuit said to the FLRA, FLRA, we think that a union shouldn't be making proposals that involve the conditions of employment of managers and supervisors at the bargaining table. And so, some of you, in applying this case law, may want to keep that in mind when you take a position that it's you may want to change the law is what I'm trying to say, or try and change the law, and get the FLRA to go with what the D.C. Circuit said. Right now, conditions of employment of management of supervisors and managers are permissive subjects. But you may want to try and change that law. All right. That was number 9. Question number 10. Does agreement on permissive provisions in a contract or MOU concerning the conditions of employment of managers and supervisors create a subsequent duty to bargain over changes to those permissive provisions contained in the MOU? And the FLRA squarely said no. And they took a case from the United States Supreme Court and applied it, and the result is in your outline in the answer to question number 10. Question number 11. Are competitive areas associated with a reduction in force permissive subjects of bargaining, even though they implicate the conditions of employment of managers and supervisors? And the FLRA came down on the side of that is a permissive subject of bargaining. Do we want to be bargaining with labor unions about competitive areas? Or do we want to follow the regs and make those decisions for ourselves? That's why I put this in here to alert you that there's a case out there that says competitive areas are permissive subjects of bargaining. So if you get a proposal that says we want to negotiate the competitive areas involved in the RIF you just announced, what you're going to tell them is that's a permissive subject, and no, we are not interested in bargaining about the competitive areas. All right. Question number 12. Can a party choose to bargain on subject matter covered by an agreement? Now, that relates to what we already learned about insisting to impasse on matters covered by an agreement. This is the opposite end of the spectrum. Yeah, if you want to bargain away this tremendous weapon that we just talked about, which is that matters covered by an agreement are something that you don't have to negotiate. And if you want to give that away, you can bargain about matters already covered by an agreement. And you've got a case there that that talks about that and that you should read. Question 13, do the permissive provisions in an expired collective bargaining agreement remain in effect until unilaterally terminated? The answer is yes, until you give notice of the fact that you no longer intend to be bound by them. So technically, they continue, but on expiration of the contract, you should be sending notice to the union. You no longer agreed to be bound by those permissive provisions. So one of the keys to this training is notifying the labor union that you intend no longer to be bound by a permissive provision. Let's go to Q&A 14. How are permissive provisions in bargaining agreements unilaterally terminated? The particular case citations that we have look to expiration of the contract as being the key time to notify, to give notice to the labor union that you no longer intend to be bound by a permissive provision. So now we got two keys to take away from this training, in addition to all the other nuances, which is you got to notify the labor union, and you do that in connection with the expiration of the labor agreement. And now we'll get to the third key that I want you to take away from the training. Must the written notice, what must that written notice contain? And look, you want to make an explicit, a specific reference to the specific permissive provision that you no longer intend to be bound by. That's the way to do it properly. Don't just tell them we no longer intend to be bound by the permissive provisions and just leave it that way. Be specific. So that's a third key to take away from the training. Notice that is specific, given in connection with the expiration of the agreement. Moving on to question number 16. There is no requirement that you satisfy a substance or impact and implementation bargaining obligation before giving that notice. The FLRA law is clear as a bell on that, and you have the case to cite. So you don't have to bargain after notice that you will no longer be bound. Notwithstanding that is a change in conditions of employment. But the FLRA has stated you don't have to bargain substance or impact and implementation after you gave your notice. That's another key concept to take away from our training. All right, Can either side terminate, this question and answer number 17, can either side terminate permissive provisions in a contract upon its expiration if the conduct of the parties has treated the agreement as in full force and effect until renegotiated? Now there's a real interesting question. In the particular case that you have, if you took a look at it and you read it, an arbitrator determined that the parties had been treating their agreement as remaining in full force and effect pending renegotiation. Therefore, the permissive provisions continued on. And in preparing for this training, I took a look at some real-life labor contracts. And guess what I found? I found provisions in real-life agency labor contracts talking about the contract remaining in full force and effect until it's renegotiated. In the context of getting rid of permissive provisions, you're going to have to get rid of that contract provision which says it remains in full force and effect until renegotiated. Or don't treat it that way. So you really are going to have to fly spec your contracts for that kind of language. And we're giving you keys and clues and things to apply to determine if they're permissive or not. And this is a real good one to keep in mind. If you're going to treat it as continuing in full force and effect, you may not be able to terminate the permissive provisions because you're treating the whole, all the subject matter is continuing on until the contract is renegotiated. Now, is a provision in a partnership agreement requiring an agency to bargain over permissive 7106B1 matters enforceable in arbitration? And the FLRA said yes. Now, 7106B1 matters, some of you may have these concepts hanging around in your collective bargaining agreements, stuff about partnership, stuff about pre-decisional involvement. You want to take a very close look at those provisions. And it may be that you want to send notice and take the position they're permissive, and you no longer intend to be bound by them. But if you don't look and very carefully look at your agreements, you're not going to discover the fact that there is partnership language still hanging around, or there is stuff about pre-decisional involvement, and it's the kind of thing that you want to jettison, get rid of. And that's how we recover, part of how we recover our management rights, by dumping these provisions that we agreed to that were permissive. Question 19. Is a contract proposal requiring a party to engage in bargaining over 7106B1 matters a proposal negotiable at the election of the agency under 7106B1? Now that one is something you need to know. So maybe the proposal says, and it's a hangover, it's a leftover, but it talks about B1 matters and the agency being willing to negotiate about them. Well, hello, this case and this question and answer is telling you that that involves a B1 matter negotiable at the election of the agency. It's permissive stuff. And we need to take a look at our contracts and get rid of that kind of thing. I'll go back to what I said at the start. We're looking for effective and efficient government use of the taxpayers' money. And some of this permissive stuff just gets in the way of the mission of the agency. Now, I cautioned some is favorable, and you've got to make those decisions for yourself on your own. I can't do it for you. You take the concepts you've learned here, apply them yourselves at your individual agencies in conjunction with whoever else is involved in bargaining about bargaining contracts, and agencies have to make those decisions for themselves. But we're giving you the tools to make those decisions. Question 20. Is the determination of whether or not a provision contained in a collective bargaining agreement is an election to negotiate a 7106B1 matter for an arbitrator to decide? Okay. You put it in the contract that you elect to negotiate over B1 matters. But you have a theory that that's not really what you agreed to do. And so you take the position that, that's not really what that provision means. It's not really that we agreed and elected to negotiate about B1 matters. If there's a grievance filed by the union and it gets to an arbitrator, this case is communicating to you that whether or not you elected to negotiate B1 matters by this clause that you agreed to in your contract is for an arbitrator to decide. And so, again, if you don't look and very carefully flashback your contracts, supplemental agreements, memorandums of understanding for permissive provisions, you may be leaving things out there that you shouldn't be. Instead, you should be sending notice to the labor union that you no longer intend to be bound by those provisions. Question 21. And this is really good stuff and really things that you need to know. And it relates back to the very first part of your outline where we talked about this new case about the FLRA, that the FLRA issued, and within which they hinted but didn't decide, but they hinted they might be reconsidering the relationship between 7106A and 7106B. Now, here is case law that talks about that same relationship. And you need to know it. And you need to understand it. And here you have the D.C. Circuit saying, if you choose to negotiate a permissive B1 matter and it becomes part of the collective bargaining agreement, the mere fact that the provision may affect a management right doesn't render that provision non-negotiable. So the agency argued, hold the phone. This provision affects 7106A management rights, therefore it's non-negotiable. And the court said, look, in looking at the relationship between 7106A and 7106B, here's what they said. These are their words, not mine. In other words, 7106B is indisputably an exception to 7106A. Well, the moral of this story is, why did you agree to put the 7106, agree to negotiate the permissive stuff, the B1 subject matter? You'd never get to this argument about an effect on your A1 management rights if in the first instance you'd said to the labor union, no, B1 subject matter, we're not negotiating. Or it involves you wanting me to waive my statutory rights, permissive subject matter, not interested in negotiating it. Or it involves the relationship between us and you want me to say the commissioner will be at every grievance procedure. Sorry, it's permissive, not interested in negotiating it. That's the relationship between the parties. So the second case also talks about the same interrelationship between A and B. And the FLRA adopts the reasoning of the DC Circuit. And in VA Medical Center 51 FLRA 386, noting, and in referring to the statute, this language compels the conclusion that where a proposal concerns a matter encompassed within 7106B, it is negotiable at the election of the agency consistent with the terms of subsections B1, B2, and B3, even though it may also affect the exercise of authority by a management official to take actions enumerated in 7106A. So I wanted you to have some tools. I wanted you to have weaponry. I wanted you to have stuff to apply if the FLRA does venture into and rethink the relationship between 7106A and 7106B. And these are some of the takeaways that I wanted you to have so that you'd have some tools and weapons in the event that the FLRA goes in that direction. All right, we're down to question number 22. Can an arbitrator enforce a permissive contract provision concerning 7106B1 matters, notwithstanding that the provision may affect 7106A rights? And if you read this case, you'll be struck by the fact that it was too late. Agency had already agreed to a permissive provision involving B1 matters that they shouldn't have, and so they're looking for an out, and they're arguing, hey, it affects our A rights. And they lost. So it goes back to what I said before. If you agree to that permissive provision and make it a part of a contract which goes to the head of agency for review, you, agency negotiators, fellow specialists, folks doing that day-to-day bargaining, you bought it. You bought it. And it's too late to scramble later on down the line to get out of the mess that you made. That's why this training about what permissive subjects are, how it applies to negotiating and bargaining, the relationship between A and B, and all of these things are tools that I really hope that you will absorb and that you will, at your agencies, make the decisions about whether you should apply these concepts, when you should apply them, and under what circumstances. I can't, and I don't presume to tell you when to do it, how to do it. That's for you all to decide. But I can give you tools to use and apply in making those decisions. So we are at the end of the Q&A. Do we have time? Is there time left to take a question? Do we have a question? There's no time left for questions, I'm being told. So hopefully we designed the Q&A to answer what we thought might be your questions about permissive subjects. That's how we designed them. So that hopefully that will have answered many of the questions that you had in mind. And I am going to defer now to my colleague, Marcus.
Thank you, John, for sharing your expert insight and guidance to our live stream audience. We hope you enjoyed today's live stream and will take valuable information about terminating permissive provisions in labor agreements. Please share your feedback about this training by completing the evaluation that was included as a SurveyMonkey link within your email containing the login instructions. We strongly encourage you to complete the survey because we not only review the responses to see how we can improve future live streams, but we also look forward to your suggestions for future live stream topics. We would like to make sure we have an accurate count of all attendees. So if there were multiple viewers who watched the live stream from a central location, please send us an email listing the total number that attended to awr@opm.gov. Thank you again for joining us today.